All right, let's dive into something you see in basically every courtroom drama. The whole case comes down to one single document, a signed confession, a secret contract, you name it. But what happens when that crucial piece of paper is just gone? Well, today we're going to unpack the really clever evidence rules that solve this exact problem.
I mean, this is the big question, isn't it? You know for a fact a document exists that could win your case, but you can't get your hands on the original. It feels like you're completely stuck. But, thankfully, the law has a whole playbook for this, and it all kicks off with a concept called secondary evidence.
So, what is secondary evidence? Think of it as the legal backup plan. It's the next best thing when the original just isn't around. We're talking about a photocopy, maybe some notes someone took about the document, or even someone getting on the stand and testifying about what they remember reading. But to get why we even need these backups, you have to understand the main rule first.
This right here is the foundation for everything else. For centuries, courts have had this strong preference for the original document. And it makes total sense, right? The original is the most reliable way to stop fraud, catch forgeries, or just avoid simple mistakes in copying. But the law also has to be practical. It knows that originals aren't always available, and that's exactly why it created a whole series of really powerful exceptions.
Okay, so let's start with the most straightforward scenario. The original document is physically gone, or it's just impossible to get. The court doesn't just throw up its hands and say, oh well, too bad. Nope. Instead, it has very specific carve-outs for these situations. The most common one is for a lost or destroyed document. But listen to this key phrase: do search. This is a big deal. It means you can't just walk into court and say, I couldn't find it. You have to actually prove that you conducted a really diligent search in every single reasonable place it could possibly be. It's a test of your effort, making sure you've really exhausted all your options before you try to use a backup.
Now, this one's a little more dramatic. Sometimes, bringing the original document to court is literally impossible. The classic examples you always hear about are things like an inscription on a tombstone or a message written on a wall. You obviously can't haul a giant tombstone into the courtroom. In cases like that, a photograph or a transcript is perfectly fine.
So what if you know exactly where the document is, but the person who has it won't give it to you? Well, if that person, who isn't part of the lawsuit, has a legal right to refuse, maybe because of some kind of privilege, you're not out of luck. The court gets that you can't force them, so it'll let you prove what's in the document through other means. You see the common thread here, right? It's all about practicality. Whether a document is lost, literally chiseled into stone, or being legally withheld, the system gives you a workaround. The whole point is to make sure crucial evidence isn't lost just because the original piece of paper can't be put on the table. All right, now for a more strategic situation. What if your opponent has the document you need, and you're pretty sure they have zero intention of ever showing it in court? Well, the law has a really clever procedure for this exact scenario. It's called a notice to produce, and this is where you see the tactical side of law. You send a formal notice to your opponent that says, hey, bring that specific document to trial. Now here's the clever part. This notice doesn't force them to produce it, but if they don't, they can't later object when you stand up and present your copy, or have a witness talk about what was in it. You've laid the trap, and now the door is wide open for your secondary evidence. It's a beautiful little checkmate. Okay, let's shift gears and look at a whole different category of documents. Think about all those official records that society needs to function. You know, government proclamations, treaties, essential business ledgers. The law has special rules for these too. And the reasoning here is just pure common sense, public inconvenience. I mean, can you imagine the chaos if for every single court case, the original books of the Bank of England had to be physically lugged into a courtroom? Or if a government office had to hand over its only copy of a public treaty? Society would grind to a halt. The law recognizes this would be completely absurd. And because of that, courts are more than happy to accept properly certified copies of these kinds of records. So for everything from public treaties to bankers' books, a trustworthy copy is good enough for the court. The name of the game is ensuring reliability without totally disrupting public business. So far, we've basically been talking about rules that are centuries old. But what about our world? A world of computers, photocopiers, and endless digital data. As you can probably guess, technology has completely changed the game for the best evidence rule. This quote just nails the modern problem perfectly. When you're dealing with a computer file, what even is the original? Is it the file saved on the hard drive? Is it the pattern of electrons flowing through a chip?
the whole concept of a single physical original just kind of falls apart in the digital age, and the law has had to adapt. And that has led to a massive shift. The old way, this tangled web of common law exceptions, it's been abolished. In its place, we have a new way. Uniform legislation, like the Evidence Act of 1995, which created a much more flexible and streamlined system that's actually built for the 21st century. A huge piece of this update was just redefining the word document. It doesn't just mean paper anymore, not by a long shot. The modern legal definition is any record of information, and that's a massive expansion. It covers everything from photos and computer files to CCTV footage and audio recordings. Basically, if it stores information, it's a document.
So, how do you prove these modern documents? Well, the new laws give you a bunch of options beyond just tracking down some mythical original. A photocopy, a computer printout, a transcript of an audio file, these are all generally acceptable now. The core idea has changed. The law now gets that for most things, a reliable, machine-made copy is just as good as the original.
So when you pull it all together, what's the big takeaway here? We've watched the law evolve from this really rigid, strict rule that demanded the physical original to a much more practical and flexible system. A system that understands that originals get lost, sometimes they're impossible to produce, or in today's world, they might not even exist in a traditional sense at all.
And that leaves us with a fascinating question for the future. We've moved from paper to electrons, but technology is moving faster than ever. In a world of easily faked screenshots, deepfakes, and AI that can generate text and images, the challenge of proving something is authentic is getting way more complex. The core question is the same, but the answers? They're going to have to keep evolving. What does the original really mean now? Definitely something to think about. Thanks for tuning in.